Dear colleagues, a very warm welcome in a new week. Today is Monday, the 3rd of November. No, actually, it's Friday. It's after bank holiday, so sorry. Today is Friday, the 3rd of November, 2023. It's 11 o'clock in the morning, and I'm very pleased to introduce Erik Tuchtfeld to you, who is a research fellow at the Max Planck Institute for Comparative Public Law and International Law in Heidelberg, and he's also an associate editor at a publication that has been discussed here quite recently and quite intensely, which is the Verfassungsblog. And that's also the reason why I invited him, because Erik is the author of a very, very interesting piece on freedom of expression, freedom of the media versus data protection versus fight against hate speech and fight against online crime. This publication is called Be Careful What You Wish For. It's published in Verfassungsblog, where, as I said, Erik also serves as an associate editor. And it's a very, very relevant publication for quite some of the topics we have been dealing with here in this blog quite frequently. This is his homepage at the Max Planck Institute. I will just refer to this also very briefly because you find all the relevant publications of Erik and people he works with there, including conference papers and articles in particular, but also including something where I would really like to mention that explicitly, including a publication which is, in my view, really a singular piece of work. I'm not aware of anything trying something similar. This is this publication, which is about a documentary of all, or at least most, of the relevant case law on content moderation and freedom of expression. So on top of what we'll be talking about here, I would really invite you to take a closer look into this, because what you see here is a really good overview about many cases in many legislations about the issues we will be discussing here. So that the two cases we might probably have a closer look into today because of the publication that I was mentioning before. That's Töchling versus Austria on the one hand, and Sanchez versus France on the other hand, are clearly not the only ones to talk about. So you will learn from this huge paper here that if you want to dig deeper into this, it's really like a rabbit hole. You will end up in dozens or hundreds of cases, and that's a very good starting point into this rabbit hole. Erik, thank you so much for coming. Let us start with the easiest question, which is, why did you write this, and what is, in your view, the main lesson to take with this text on Be Careful What You Wish For?
Well, first of all, thanks a lot for the invitation. It's a great pleasure to be here in your podcast, and I must admit, it has been one of the kindest introductions I've ever heard about myself. So thanks a lot for that. Why did I write this piece in the Verfassungsblog? So there were several recent judgments by the European Court of Human Rights, in which the court, in obiter dicta, so without the actual need to take a stance on it, mentioned that it is in favor, or that it is desired to that platforms have some kind of filter system. And this was first in Sanchez, where it was actually to some extent totally unrelated, and now in Zöchling, where it was the actual case, but still only mentioned as an obiter dictum and not as a necessary requirement to fulfill positive human rights obligations. And I think that it is kind of worrisome. That's why I also titled it with "Be Careful What You Wish For," when in human rights court mentions filter obligations, which have been heavily disputed in the last years, because what filter systems do when they filter content before it is actually published is pretty close to what at least our German classical definition of censorship is. So a preemptive evaluation of content with regard to its lawfulness. And I think that this is a problematic turn the court has taken in its recent decision. So, and I felt like there's not a lot of attention on it. So I wrote this piece to bring some attention to this, in my opinion, varying statements. and to also spark a debate is about if that really is something we should wish for, or if in particular from a human rights perspective, from a freedom of expression perspective, other mechanisms to fight hate speech are more effective and more desirable to also still enhance freedom of expression while protecting personality rights in the digital space. Oh, I think you're still muted.
Oh, I'm still muted. One of the funny things that happened after you having written this piece is that, I mean, the debate has in a way come to everybody's attention because one of the, I would assume at least, because one of the officials within the European Union being in charge of this, in particular the Digital Services Act, which is the EU attempt, the most recent EU attempt to try to find an equilibrium between freedom of speech and fight against hate on the internet. So this representative, which is Thierry Breton, who is the commissioner in charge of the enforcement of the DSA, started to write letters, very interesting letters, to major platforms, X, to Twitter, and others, reminding them of the Digital Services Act and the obligations coming with the Digital Services Act after the beginning of the war in Israel and the attack by the Hamas on Israel just recently. And when you read this this letter that came into very heavy criticism quite quickly, as you know, you have the impression, or I have the impression at least, that the overall mainstream story that is told by people like Breton is that the problem we have on the internet is not so much that we have a freedom of speech problem there, that people are not able to say what they want to say, and that censorship is a problem, but that the opposite is a problem, which is we have too much hate, we have too much disinformation, etc. on the internet. And what I find really interesting in your paper is that you're taking the other point, right? You are making the other point, which is, well, actually, of course, there is a problem with hate and there is a problem with disinformation, but we need to take things serious there and separate them and legally treat them properly and differently according to what is on the table. But that we also have the other problem, which is we need to be careful that we do not fall into a censorship trap.
That is
I think
exactly right. If I might jump
I
in
think
there.
you probably read Breton's paper or Breton's letter also with great interest. Would you like to comment on this also in relation to your article and to your other work?
Yeah, most definitely. First of all, I want to, as you mentioned already, but I want to emphasize that I do not deny that there's a problem with hate speech and disinformation in the internet, and that this is a serious and troubling problem. I'm just a little bit afraid or concerned that the measures taken by, for example, the European Commission right now, in particular, European Commissioner Breton, are the right ones. They want to show their powerful fist, their strong fist, towards rogue social networks, and obviously, in particular, X and Twitter, with Elon Musk as somebody who's a very prominent figure, and also, in my personal opinion, a very difficult figure. And it shows that that our digital public spaces should not be ruled by these kind of persons, in my personal opinion. That is what I think is the motivation, what drives, in particular, Breton, which, I mean, he's not simply acting towards X, towards Twitter, but he's acting in a very particular way. In this, he's publishing open letters on the network itself. The network he criticizes, he's using for publishing open letters to the CEO. I think this is problematic from a variety of reasons. First of all, what he's mentioning in the letter is quite concerning from a legal point of view, because he's, for example, equating disinformation with illegal content. And those two are separate categories. Both are concerning, but in most of the cases, what is disinformation is not illegal. What is illegal is often, I mean, at least illegal hate speech. There's also a lot of hate speech, which is so-called wait, Anlisa, now I'm lacking it. There's a very nice phrase. Awful but lawful. That is what I was looking for. Awful but lawful content. So there's a lot of hate speech which is not even illegal, but there is also a lot of hate speech which is clearly illegal, and you can tackle this. And platforms are obliged to take it down at least when they receive reports about such kind of hate speech. But when it comes to disinformation, in most jurisdictions, at least in the European Union, disinformation is lawful. It is simply not illegal to lie. Might be illegal when it concerns, for example, defamation, and in particular in Germany, also when it comes to the denial of the Holocaust. But apart from that, when I tell the public that COVID masks do not work, obviously that is wrong, but it is not a crime, and it's also not prohibited to say something like that. But it is still concerning, and we need to figure out how to address these kind of issues in a democratic society, in a liberal society. But it is most probably not the right way to simply give the power to governments. And I mean, the European Commission is the European government to decide what kind of content they deem not to be true, what kind of content should be simply removed from the platforms. And this equation Breton is doing in his letters, equating illegal content, which is mainly hate speech from a legal perspective, and disinformation is really troublesome, because, as we all know, the fight for truth and the definition of what is truth in a democratic society is something which needs to be built bottom up. So the society itself must go into a debate, must exchange arguments, and then also decide what is the truth, what is the narrative they are following. And it must not be governments who decide what is right and what is wrong, what is truth and what is lie.
Yeah. So certainly, this Breton letter is a very good example for the blurring out of the differentiation between illegal content and awful but lawful content, and Breton is certainly not stupid. So I think politically, this is done on purpose in a way, right? So there is a message behind this, or there might be a message behind this, also perhaps to foster the understanding, or at least the knowledge about the DSA via this instrument, because of course in this war everyone is now concerned about everyone is concerned about the amount of disinformation coming, in particular on Twitter and other platforms. It has become completely impossible to get an appropriate picture about what's really happening in important areas of the world, and this problem that is understandable to everyone is a very good instrument then to make an argument that we need legislation in the domain, and that the DSA is the right answer to this problem. However, as one needs to know, the DSA is neither new. I mean, most parts of what we see there are already in the e-commerce directive. Nor is it really dealing with disinformation in the sense of that it needs to be put off the internet. It's more, things that need to be put off after a notice and takedown procedure are illegal content. So something which is clearly, obviously, to illegal. And the interesting, now coming back to your paper, in my view, one of the interesting aspects of the paper is that you are making this point very, very clearly, that first, this is not new, so that we have quite some traditions here, both in the US, but also in particular in Europe with the e-commerce directive, but that also we have some kind of both views in the European Court. So on the one hand, we have the European Court in matters of, the European Court of the European Union in matters of interpretation of the e-commerce directive, and possibly another Austrian case, Glawischnik-Pistek would be the one to mention here. And on the other hand, we have the court in Strasbourg dealing with the Convention on Human Rights, having a very, at least according to you, a very different approach than one would expect with an EU background on the matter. May I ask you perhaps to make the point in how far, in your view, the European Court on Human Rights is not really in line with the EU tradition on dealing with the matter, to make this argument perhaps a little bit more clear to the audience than it is at the moment? Due
Yes,
to
yes,
my
of course.
stupidity, obviously, because I don't ask the right questions yet, but hopefully we will come there, right?
Yes, yes, of course, I'd love to. So I think it's important to understand the background from where we're
Mhm.
coming from in the regulation of platforms, which is classically the regulation of hosting services. So there were always liability exemptions for them. There we have a very prominent liability exemption in the United States from the 90s, Section 230, which basically says there's no liability at all for platforms which leads to a situation where they have the power to take down or to leave any content as they wish on their platforms. And this is also called the I think 23 words. Section 230 contains 23 words, if I'm not mistaken.
26, I think,
23.
but I prefer to
26, yeah.
that's
The
26.
26 words
Yeah.
which created the internet. Because
Mhm.
they are so important, because the rise of social platforms as we know them today can only be explained by taking a look at this liability exemption, because you can only offer your services to other and let them upload content as they wish. And today it's billions of users uploading their personal content on these platforms. When you're not liable for that, when they can upload whatever they want, because if it's illegal, nobody can come to you and ask you to pay them damages because some content which is being published on your platform by another entity, by a user, is illegal or violating their rights. And only because you have this kind of liability exemption, the platforms as they are at the moment could gain that much, such a big market share, and be a public space basically for so many users. In Europe, we have taken a slightly different stance. So there was never this like more or less. There are some exceptions, but I won't go into too much detail into the US American law. But there's never been this approach of a more or less absolute exemption. So there was always the idea of the notice and take down procedure. So a platform is not liable as long as it takes down the illegal content after it has been noticed. So you don't have to monitor the content. This is very important, the prohibition or no obligation of general monitoring. You don't have to monitor all the content which is on your platform, but once you receive a notification as platform, you have to act. You have to evaluate it from a legal point of view. And if you come to the conclusion that it is illegal, then you have to take it down. Otherwise, you become liable. So that is the background where we're coming from, which is very important for the Web 2.0, the social web as we know it today. And then there was the Delphi case by the European Court of Human Rights, where a news platform, actually, it's really interesting that it has never been this big social platforms in these cases, apart from Blavishnik and then the European Court of Justice. But in particular, before the European Court of Human Rights, it was always like kind of smaller news portals, which had only national reach. So there was the Delphi case in 2013 before the
Mhm.
European Court of Human Rights, later confirmed in 2015, if I'm not mistaken. But the first judgment in 2013, and there the courts in Estonia held the news platform liable for not removing illegal content, illegal comments, hate speech proactively. And that is something which is rather not compatible in my from my point of view with European Union law. But that
Mm.
was not the question before the European Court of Human Rights. The European Court of Human Rights had to decide if such an obligation to monitor proactively the comments and thus the content on your platform is in violation of the European Convention on Human Rights. And the European Court of Human Rights said that there is no human rights prohibition for a state to oblige its platforms to do such monitoring. So it gave the states the option to establish some these kind of obligations. So we really have to have in mind that these are two separate but interconnected legal regimes. We have the European Convention on Human Rights, and we have the European Union law with the e-commerce directive in the past, and the Digital Services Act now. And these are separate but interconnected because both courts, in particular the European Court of Justice for European Union law, takes into account what is happening in Strasbourg with the European Court of Human Rights. So, as I said, in Delphi, the European Court of Human Rights decided, okay, platforms can be obliged to monitor their content from a human rights perspective, but it did not say that platforms have to be obliged, that there is a mandatory human rights obligation to monitor content. Yeah, so that was the situation for many years. European human rights law allowed an obligation to monitor content, but at least member states of the European Union, one has to have in mind the European Convention and its member states, is way bigger than the European Union with its 47 member states, European Union only 27. But the European Union law, member states of the European Union, they were prohibited to establish such a general monitoring obligation because of the e-commerce directive, so European Union law. So that was the situation. It was kind of a standoff. Actually, there was no conflict between these two legal regimes. They had like different stances on this issue, but they were compatible with each other. And now the European Court of Human Rights said in Sanchez for the first time, and in so-called obiter dictum, so in a reasoning which is not important, which is not like carrying the decision that it is at least that there can be, I think the formulation, I opened it myself, was that there can be little doubt that a minimum degree of subsequent moderation, or, and this is important, automatic filtering would be desirable in order to identify clearly unlawful comments as quickly as possible. So what the court here says is that there is it is paragraph 190 in the Sanchez judgment. So what the court here says, that it is desirable from a human rights perspective to enable automatic filtering, something which is at least, I mean, desirable is still a weak statement. This becomes clearer in Zöchling. This is also why I used Zöchling as very concrete point of starting point for my blog post. But that automatic filtering is desirable. That would still be to some extent compatible with European Union law, because platforms, while they cannot be obliged to look for illegal content, they are free to do so, and many platforms do that. Of course, when it comes to in particular when it comes to so-called CSAM, so child sexual abuse material, they have automatic filtering systems in place because they don't want to wait for reports to take it down, but they want to do it proactively because they have an interest to not have such kind of content on the platforms. But what Sanchez and also Zöchling was about was hate speech. And what defines hate speech is incredibly difficult. We had here in Germany, we had the so-called Kühners cases, where dozens of lawyers, well-educated judges, had very different interpretations of what constitutes illegal hate speech. So it's very difficult. It's very much context related. And now there's a human rights court who says, okay, let us do the machines. Let us do automatic. This should be done via automatic filtering. And it becomes, and there's the conflict starts in Zöchling, because Sanchez was a case about the obligations of a politician to take care of its own Facebook wall, on its own Facebook posts and its comments. But in Zöchling, it was about the obligation of the state to hold a platform liable if it does not have such kind of filtering systems in place. And this means that the court seems to be on the opinion that there is a positive human rights obligation to establish automatic filtering systems for the states, so that the states have to oblige platforms via their own national law to create automatic filtering systems. And this would clearly be in conflict with European Union law, because European Union law, you're highlighting it right now, it's paragraph 13 in the Zöchling case. European Union law prohibits the member states from establishing such an obligation. And this is going to be quite difficult to find an equilibrium between these different legal regimes, these different legal obligations. And from my point of view, it is right and it is better what the democratic legislature, the democratic legislation has done in the e-commerce directive and also in the DSA to make clear we can, in the internet as it works and as we want it to work, we need to give users the possibility to publish their content, and there shouldn't be any kind of preemptive censorship with establishing some kind of control if the content they would like to put out there is illegal or is legal in advance.
Mm-hmm. Wonderful, Erik. Thank you for summarizing this. May I kindly challenge this now a little, if I may, right? Just for the purpose of this meeting here. So the first remark I would like to share with you is that starting with the very beginning and the U.S. legislation and then also the e-commerce directive, as you said, the U.S. legislation, which by the way, interestingly, was also already about children's protection on the internet. So that is some kind of 30 years now ago and still on the agenda. So as you put it, this was the 26 words that invented the internet, one could say. One could also say the 26 words which brought us this dystopian world of social media bubbles without any media controlling that anymore, right? So because the rise of all the social media channels, as you know, came with a decline of the traditional media services in parallel to this. And in traditional media services, we've seen for many years a very clear point, which is if you are a media service and you publish something, no matter whether it's you writing it or whether it's one of your readers, you are fully liable that this is in compliance with everything. So one could argue, and I think quite some of the traditional media houses still argue, that the whole starting point was an error and that we should go back to something which is now 30 years old and reinvent the internet in the sense of that the traditional media rules also apply there. And nobody from any media house would call that censorship. They would say it's responsibility or professional ethics or whatsoever. So that would be my first issue where I would really like to hear your comments. And the second issue is the following. I completely share with you, I very much share with you, your impression that the Court on Human Rights has some kind of reading here, in particular in circling, going into the direction that a social media platform should take care of this content moderation issue because they caused the problem by some kind of unknown, miraculous IT infrastructure that is not invented yet. So I fully agree with you. I also think. I mean, you see this also, by the way, in my view, at least in the decision of Klawischnik-Piszczek of the European Court, that they also seem to believe that there is some kind of superpower out there allowing to understand the meaning of a statement with automated means without really giving us any indication how this should work, in particular because it's impossible, or at least to the very best of my knowledge, impossible to fully take context into consideration by automated means when you're talking about political speech, and that this is very, very difficult. So the question now coming is, what would be the alternative then if one is of the opinion, just like the European Court of Human Rights seems to be, that there needs to be some kind of content moderation by a miraculous superpower of IT, if that is not existing? Would it then be that we need millions of people reading everything so that no longer there would be any social media service available because you can't pay for this? Or would it be that we need to change the law?
Well, with regard to the first point, I mean, of course, you could simply argue that social media did not benefit the world. I mean, this is a very it's a highly disputed topic. If the rise of social platforms,
but that's not so much my point here. My point is that this advantage, this competitive advantage, that you could argue as Facebook that you don't need to care about what people are doing on your platform, ruined traditional media. or was one of the
Be-
factors ruining traditional media. I mean, there are other factors too, but that is something which is, I would call it a level playing field. It's not so much about whether Meta did anything good for the world, right? That's another topic. It's more about, is there or was there a level playing field in this new market? And one could argue that there wasn't or there isn't, and that this is a misconception.
Yeah, well, the question to me, well, first of all, the Facebook, Twitter, and others, they have to care, right?
Mm,
So it's when I mean, let's take the U.S. American legal situation and let's put it away for a moment and think
mm,
about the situation in Europe. So there has been since more than 20 years, there's the notice and take down mechanism. So whenever Facebook is notified, so any user on the platform, I mean, there's a billion users. If any user is somehow disturbed by a piece of content and reports it to Facebook, Facebook is liable for this content if it's illegal, if it doesn't take any kind of action. So there was
mm,
never the situation in the European Union where these social platforms could simply not care. They could, in fact, I mean, that was like, I mean, there is probably a difference between the law and how the law is executed. And I think
mm,
for quite for a long time, there was a lack of execution of these laws. I mean, all the decisions we are talking about are from the last 5 6 years, while the
mm,
law stands as it is for roughly 25 years.
mm.
So somehow courts didn't care, or supervisory authorities didn't care, or there was simply no kind of jurisprudence on this. But I would try to push back this narrative, which is taken by some that platforms were not liable at all in the European Union before now the DSA came or something else. We always
Yeah.
had notice and take down.
Yeah. If I may, however, sure, true. But there are, as you know, there are thousands of complaints that didn't really work, and there are many cases that I could cite now indicating that it didn't really work in the sense of that somebody who was the victim of illegal speech on the internet got that content down easily and got some kind of uh, case in front of a national court easily. That was not the case. But that's not so much my point here. My point is there is a difference if you are if you are a flea market and you
Mhm.
argue, I don't, I offer the possibility to do whatever you want on that flea market, and just in case that somebody starts selling drugs, and just in case somebody starts selling drugs and I get aware of this, I will start chasing this person. And unfortunately, I will not succeed because it's a different legislation, or I don't know, data protection or whatever argument. That's fundamentally different from, I'm a traditional news editor. I need to pay 20 people working for me because I need to take the responsibility for the content that is out there, helping people to put things into order, which is what media normally is doing. And including also one of the 20 guys working for me who is doing nothing else but reading letters to the editor, deciding on whether they should be published and whether they are worth being published and whether they are legal, etc. And that's a different game. And the
Yeah.
problem now, one could argue, is perhaps it's a different game. At least legally, it certainly was a different game. But the outcome of this that we see now in 2023 is that one of the two games is clearly dominating the other in a way that is not really beneficial to society, one could say, right? And then one could say, okay, let's go back to the starting point, which is it's one game and not two, and we need to regulate them similarly. And this is not really a problem of censorship. It's a problem about how do we organize information in a Western society.
Yeah, I mean, why I started my last answer with the question is social media good or not for the society, is because I think it's basically on the question, who publishes content, and if it's just a selected group of editors like it is with a traditional newspaper, or if it's eventually and possibly everyone, how it is on social platforms. And we can come to the conclusion that it shouldn't be everyone. I mean, everybody, like when I'm publishing a piece of content on social media, of course, I am personally liable for that. But if we would change the system that platforms are liable for every piece of content on their on their platforms, then social media simply wouldn't exist as it does. And one could argue, I don't think that it's totally like an absurd thought, that social media, the rise of social platforms, maybe did not benefit society. But it is not my personal conviction, because I also think that we have all these movements which also started in social media, and where social media was very important for a democratic uprise. One could think of Black Lives Matter, and one can think of Fridays for Future, which of course is a very strong digital element as well. We had all the hope in the Arab Spring, and all of these kind of movements, which at least also occur to a substantial amount on social media, were only possible because platforms didn't have to check the legality of every single piece of content before they publish it. So because everybody becomes a publisher, I think also I think there are a lot of negative effects, and I don't think I'm not arguing for a world where there is no content moderation. I do think that content moderation is very important, that it must be improved, and that the current situation also is very often it is the poorest people and the poorest countries who are doing the dirty work here. Poor people in the Philippines who have to check uh, on the content which is published, and that this system is simply not fair. But I don't think that the liability problem is actually the problem which led to the situation where we are with hate speech, and with this aggressive online debate. I think it is too easy to simply point towards the difficulties with notice and takedown, to make it
Yeah.
responsible for the online discourse we have at the moment.
Yeah. Let me just, if I may, to make two more points here, and then let's perhaps
Yeah.
go to the other question, because that's more related to your article, which is the more important thing here. But two more minor remarks here. The first one is, you're completely right with the Arab Spring and all this. On the other hand, one must also state that we are, as Europeans, in a situation now that the existing governance has brought us into a situation where traditional European media companies are clearly struggling. Many of them go bankrupt, as you know. And on the other hand, we have mainly US or Chinese-driven social media platforms dominating the whole market, and not necessarily. I mean, this is one of the, in my view, at least, one of the reasons why Breton started writing these letters, not necessarily being too interested in European values and European governance structures and all this. I mean, one of the funny reactions on the Breton letter was Mr. Musk answering that he doesn't really even know what Breton is talking about, right? I mean, this is the utmost disaster, in my view, a politician can run into, that one of the people you want to target with your legislation tells you in public, with millions of people reading it, listen, I don't know what you're talking about, and I don't really care, right? So that's just the one point, right? We are in a situation where Europe is really struggling with this. And the second point, I don't know whether I really buy the argument that if we didn't have Section 230 and the e-commerce directive, there wouldn't be any social media, because of course there's plenty of space in between. For example, just to mention one thing here, one of the reasons why we have so many problems on X, in my view, is, or not only in my view, but also in my view, is that there are so many people there who are not known, right? There are pseudonyms, bots, whatever on that platform, in particular bots, many of them potentially run by military organizations having strategic geopolitical goals with this. And it would have been very simple to say, I mean, in theory, it would have been very simple to say, listen, if you are a platform and you want a liability exemption, the minimum we require is that you identify whether the person registering on your platform is actually a person and not a bot network, right? So that, just to mention one thing here, right? So I'm not sure whether the argument, if we had gone the other way, we wouldn't have any social media, is really completely convincing.
Well, it's I mean, it's a very interesting discussion. I really enjoy it. Uh, some minor thoughts on this. The first one would be on anonymity. I mean, you didn't say that you're against the anonymous use of
No, I didn't
social
on purpose. I didn't, because I
yeah.
didn't want to
Okay.
start this real name debate. And so I made another point, which is please clarify whether it's a human.
But how would that look like in
I
practice?
mean, there are plenty of, not my business, but I know that there are quite some solutions out there on the internet trying to identify whether they do these stupid things with, identify the horses or, divide 42 through 7, what's the outcome and all this. All of us are aware of this. And the purpose behind this is, let's see whether it's a human sitting behind that machine, right? And I don't know whether that would have needed, or whether that would help at all, right? But it would be something one could consider as being something a platform should take into consideration, not leaving it completely up to them whether or not it's a bot, and not really leaving it up to them, telling us then, listen, I'm sorry, we have a problem here, but we can't solve it because we don't know with whom we have a contractual relation here.
Well, that is a fair point, and I have no objections against the use of captchas. I mean, they're really bothering me, and I always feel that it's kind of an insult when a machine tests me if I'm human or not. But apart from that, I have no objections against the use of captchas to verify if somebody is human or not. But I do actually think that they are used by the platforms already, and that they have mechanisms in place to try to stop bot behavior because they don't like it. It doesn't bring them any ad revenue. That is what they're actually interested in. I think what is their business model? Their business model is selling ads, and bots do not click on
Erik,
ads.
sorry, I don't want to interrupt you. I think and I don't want to be offensive here, but I think of course the business model is selling ads, but the key indicator about selling ads is how many users you have, and growth rates is about one of the most prominent factors of success in social media. So I think my priority, if I were someone deciding in any of those networks, I would say, listen, we need to have the best possible growth rate, and let's not so much take care about whether it's a bot or a human. And just to come up with 2 or 3 more examples of this, for example, as you know, all of them have a theoretical age limit, which is do not go on the platform if you are younger than 13. And as you also know, all of them don't really care. I mean, the only thing that you need to do is to put in another age there, and that's it. End of story. Everyone below 13 at the moment is using TikTok. I mean, I don't think that there's any European kid out there under 13, let's say between 12 and 13, not having had any kind of contact with all those platforms not being made for them. And I'm not yet talking about pornography here, which is another huge area, obviously, where we have the same problem. And the third problem, just to indicate the third one here, is the real name problem, right? I mean, Facebook, for example, has a very long tradition in indicating you need to be there with your own name, and please don't use a pseudonym. And at the same time, not really enforcing this, right? There are plenty of people using a pseudonym or being a dog or whatever on Facebook in contradiction with their own terms and conditions. So the only point that I want to make here is I don't think that it's that simple that if we hadn't had the e-commerce directive or section 230, the internet would look completely different. That's what I want to say.
Okay.
Sorry.
I respectfully disagree. I respectfully, because I think it is quite important. I'm sharing all your concerns. Honestly, I'm sharing the concerns you have with regard to age-appropriate design of platforms. Age verification is a very sensitive issue because I think that anonymous accounts or being able to act anonymously on the internet is crucial to freedom of expression, because the question is for whom do we need freedom of expression, and also who's affected the most by hate speech at the moment. The answer to both is marginalized communities, and they who in particular now need protection against the attacks of hate speech they are suffering from. They are the same who also need the protection of anonymity to be able to express themselves, because otherwise they might suffer repercussions. That is quite a short perspective on the question of real name systems, on any kind of verification system. I do not think that because of that, any kind of verification system is bad. I just think that you have to have in mind for whom are you actually establishing these kind of systems, and are you actually doing them a favor when offering a system like that?
Yeah. Yeah.
And I think that while liability exemptions are crucial for the development of the internet as we have it today, at the same time there's a big difference between Section 230 and the e-commerce directive and notice and take down. And
Absolutely.
yeah, this narrative of the I mean, there might have been a complete liability and absolute liability exemption for 15, 20 years in practice,
Mhm. Mhm.
but that was not so, or maybe it was also a problem of the law. But I mean, from a theoretical standpoint, the law allowed also systematic takedowns. I mean, Glavishnik, you've mentioned it already, was a decision under the e-commerce directive, a law which then stood for 20 years, but it took us 20 years to have such a decision.
Mhm.
Um, so the question is, yeah, I think it's where you say it's not that easy to say it
Yeah.
without the e-commerce directive, we wouldn't have social media as we have it right now. I
Mhm.
think it's a bit too easy to say it's the liability exemptions are the big problem, the main problem we have when it comes to the online discourse as it is right now.
Yeah. I certainly very much agree with this. Certainly. Perhaps, if I may, Eric, should we come back to the second point, which is the question about the technicalities of doing this, right? So this content moderation
Yeah.
and the statement that both courts, in my view, at least, have a rather naive understanding about how automated
Mhm.
content moderation should look like, and or could look like. And I read your paper also buying this argument, which is it's not that simple, right? So content moderation by automated means doesn't work in the way lawyers think that it should work. My question then was, what is the alternative then? If we don't want to have millions of people in the global south being very poorly paid or not paid at all, and for content moderation of content that nobody wants to see, is then the only alternative, wouldn't then be the only alternative that we have to change the law? Coming
Yeah,
back to the point we made before. Mhm.
this is a very good and definitely the most difficult question. What is the alternative?
Yeah.
I must admit that I personally come more and more to the conclusion that, and this might be something you sympathize with after the discussion we just had the last 20 minutes, that global networks are not the solution. That global networks, global social media platforms do not benefit society, and that they're one size fits all approach. I mean, there's one set of rules which is established in the Silicon Valley, and which, of course, incorporates their own values, but not the values of Europe, and in particular, not the values of cultures and states all around the world who are all using these kind of platforms. This is basically the main problem, or that we might also experience maybe an end of the global platforms as they have existed the last 20 years. But the question is, what is the alternative? What is now to come? I personally, I'm quite a big fan, at least theoretically, of what is called the Fediverse, where we have a multitude of different so-called instances who then can talk to each other, but that you have smaller communities who set up their own set of rules, how they want their content to be moderated on their platforms, and which also, in my experience at least, leads to less to a decrease of all these problems, because there's while it's not while it still is like anonymous in the way that you don't know the real names of other accounts, it's
Mhm.
smaller communities who somehow have a sense of belonging together, a sense of solidarity. So there's a lack of aggression, or there's less aggression than it is on these global platforms where you simply scream at strangers. So I think this might be a different structure of the social web, might help to solve these kind of problems. I mean, yeah, I don't think that this will be the
Mhm.
final solution for all the problems. And of course, we also need, and of course, I think there are cases where automated recognition of illegal content might make sense, in a sense that there's still some kind of human overview if it is a false positive or if it's correct. For example, when it
Mhm.
comes to the distribution of child sexual abuse material, but I strongly oppose it in the area of of expression in a written way, because understanding text and understanding statements is extremely context sensitive. And when you simply prohibit certain slurs or certain insults, people will still be able to insult to insult each other simply by becoming more creative. This is something we see everywhere. For example, when it comes to online gaming, where this censorship, I would call it, or this blocking of particular words is very common. People have no problem at insulting each other still. So it remains a social problem. And while, of course, our technical infrastructure also leads to particular social structures, I think it is too easy to simply point at a particular technology to solve this issue, as the courts seem to do it in their recent decisions.
Yeah, true. Just one remark, if I may, to the Fediverse. So, just like you, I was very enthusiastic and positive about Mastodon appearing last year, and I was really one of the early adopters, I think. However, what I see now, and you certainly do the same, is that actually, quite a few people got there, and many of them now are running to Blue Sky or leaving directly to Blue Sky, which is just another mainly US-driven uh, monopoly kind way of dealing with the Fediverse, right? So I share your views, but I'm not that optimistic about whether the argument is decisive for quite some of the users. Erik, one point that I still want to discuss with you, if I may, and that comes back to you making quite some interesting legal arguments in this paper. I think one of the really interesting aspects is that you are working out that there is a fundamental difference in the understanding between the European Court on Human Rights on the one hand and the Court of the European Union on the other hand, in the understanding of whether or not there should be some kind of content moderation, without going into any further details now because we discussed this already. My question now is whether you think that this conflict, if it is there, calls for a new way, and if so, is this new way possible under the existing legal framework, a new way how those two courts should align their points of view and their jurisdiction?
Yeah, it's very difficult. I mean, my impression is that the European Court of Human Rights didn't know what it did. This was a decision taken by only three judges, because the court felt like it is on an established field here. Like there is clear jurisprudence on it, and there's little need to discuss this in a bigger setting. And I strongly disagree. It really gives me the impression that the court didn't know what it actually is doing there, or that it didn't like had the impression that this is some kind of revolutionary approach to media liability, as it is in my opinion. So what I'm also trying with this article is to point towards this towards the situation that there is a fundamental conflict, and my hope is that the courts are reading it and that they at least see the conflict, and that they act with more caution in possible future cases, and somehow position themselves towards the jurisprudence of the respective other court. I mean, in the last part of my of the article, I do shortly speak about possible interpretations which are sparks of hope, as I notice, is to align these two approaches. One would be to understand well, first of all, it is an obiter dictum, right? So it's not legally binding in a narrow sense. The court would have to confirm these findings, these rulings, in another decision to make it a legal obligation for all member states of the Council of Europe, which are member state parties to the European Convention of Human Rights. The second thing is, I mean, it talks about automatic filtering and a subsequent moderation. Subsequent moderation is clear. There is a need, and it is very much desirable that there is subsequent moderation. I would argue it should be done by humans. But combining these two approaches could lead to a situation where we understand automatic filtering or only as some kind of flagging system, that a content is flagged which is somewhat problematic, and then the actual moderation is carried out by a human moderator, and it's also not done preemptively before the content is published, because this is, in particular from a German perspective, this is the problem. The problem is not that content is removed or not. The problem is that it should be checked before it is published, which is what we understand when there's a state obligation to check on content before it is or to evaluate the legality of content before it is published. This is what we understand censorship as censorship from a German perspective, but that is subsequent moderation, and that also automatic filtering mainly has the purpose of tagging and to filter, like do some kind of pre-filtering, which is then later be evaluated by human moderators, and they decide if a content should be removed or not. I think such a reading would be possible of the European Court of Human Rights judgment, and would align with recent judgments of the European Court of Justice and also the Digital Services Act.
So let's see whether this is the way it's going. Will be very interesting to see. And I mean, one of the interesting aspects of all this is that it's also a strategic question now for lawyers to, if they consult clients, whether they should mainly focus on the European Union's regulatory framework, trying to get the case in front of the Court of Justice of the European Union, or whether it's more about the convention, and whether the right approach would be to go into this direction. And very difficult to tell, at least at the beginning. And interestingly, as you rightly mentioned, quite some of the cases are with very prominent news services. So that brings me back again to that there is also a strategic question behind all this, which is how should traditional media houses argue legally and politically in this whole domain. Thank you so much for this, Erik. I really enjoyed the conversation, as you certainly saw. I ask everyone, please, again, consult this paper. You should really read it. There's plenty of new argumentation in this already. And then, of course, in particular, if you really want to dig deeply into this, then look into this, and also and last not least, look into all the other publications that Erik kindly made available, in many cases in an open access format, so that it's very easy to jump into this. There's plenty of more material available. For the moment, thank you so much to you, Erik. Thank you to everyone who listened to this. It was a pleasure. I hope that all of us stay connected, that you stay interested, and that all of us stay as healthy as possible, or become as healthy as possible, as quickly as possible. Take care and all the best. Bye-bye.
Thanks a lot. I enjoyed it a lot. Bye.
Thank you.